In 1961, Clarence Earl Gideon broke into a pool room in Florida with the intent to commit a misdemeanor offense. He was caught in the act and had a court date set up at the Bay County Circuit Court in Panama City. Gideon, too poor to afford a lawyer, requested that the state supply him one. He believed that the 14th and 6th Amendment gives him the right to counsel. His request was denied because of the precedent that Betts v. Brady set up in 1942, saying that the right to counsel would only be allowed to defendants in capital offenses. In court, Gideon represented himself and was subsequently convicted and sentenced to 5 years in prison. He thought this was not fair at all, so he filed a petition of habeas corpus to the Florida Supreme Court. They read it, but ultimately agreed with the court's decision. Gideon, while in jail, filed a petition to the U.S. Supreme Court, who decided to review this case in 1963. The Supreme Court delivered a 9-0 unanimous decision in favor of Gideon. Justice Hugo Black wrote the majority opinion, in which it was decided that since the 14th Amendment gives the right to due process of law, the 6th Amendment should be applied to all criminal cases. In other words, the framers of the Constitution put a high value on the right of the accused to have means for a proper defense. Justice Tom Clark wrote a concurring opinion in which he noted that the Constitution makes no distinction between capital and non-capital cases. Therefore, it is unconstitutional to allow right to counsel in one, but not in the other. Justice John Harlan also wrote a concurring opinion. In his eyes, Betts v. Brady should be overruled, but it should be entitled to a more respectful burial. Under Betts v. Brady, the belief that counsel was denied to those who could not afford it in all non-capital cases was not true. There were special circumstances in which the state did supply an attorney to a defendant. For example, in Powell v. Alabama in 1932, the defendants were young, illiterate, and stood in deadly peril of their lives, so they were supplied an attorney. Justice Harlan believed that since special circumstance was abolished in all capital cases, it should also be abolished in non-capital cases. Finally, Justice William Douglas wrote a separate opinion in which he gave a brief history of past rulings of the court, showing how the court has always tried to protect the 14th Amendment. Clarence Earl Gideon, the unlikely American hero. Who knew a criminal with only an 8th grade education would change the way our legal system works?